Hi guys, welcome back. This is our third installment for Civil Liberties here. So we left off, we were talking about the Supreme Court, and we were looking at Mapp versus Ohio, and then also on the U.S. Patriot Act. So what we want to do is we want to continue looking at defendants' rights, and we want to look at the concept of self-incrimination. The Fifth Amendment protects you from self-incrimination. It states that you basically don't have to testify against yourself or put yourself in a position where you could incriminate yourself. So you will often hear people when they take the stand, you probably have heard, I plead the Fifth. What they're saying there is, I plead the Fifth Amendment. I'm going to take the Fifth Amendment. I'm not going to answer these questions because they could be self-incriminating. What that also means, though, is that we also don't have to answer questions from police officers after a certain point. We do have to tell them our name and things like that. You don't have to answer anything else. There's a couple Supreme Court cases that we're going to be going over here. Miranda versus Arizona is this bizarre U.S. Supreme Court that happened in 1966, where Ernesto Miranda was basically accused of kidnapping and raping a woman. He was picked up by the police. He was put into an interrogation room. He was basically interrogated for several hours, and eventually he confessed to the crime. Now, Ernesto Miranda basically had like an elementary level education. He didn't know his constitutional rights. He was illiterate. He couldn't read his constitutional rights. And basically what they did is they basically said that his confession shouldn't be used in his trial. The trial judge disagreed and allowed it in, and the jury didn't take very long to convict Ernesto Miranda. So they appealed and eventually went up to the Supreme Court and became Miranda versus Arizona of 1966. And during that basically Supreme Court case, they argued that the police should have the responsibility of informing you of what your rights are. And eventually the Supreme Court agreed. Now, Ernesto Miranda didn't get to go free. They instead had a second trial for him, but this time they basically were not allowed to use his confession in the trial as part of the evidence, but they didn't really need it. They had some other physical evidence, they had testimony, and they actually had Ernesto Miranda, apparently the night of the assault, went home and then told his girlfriend what he had done, which seems like an odd conversation to have with your girlfriend. So they were still able to convict him. He went to prison. After a while, he got out of prison and then got into a bar fight and was killed in that bar fight. And when the police wanted to talk to the individual they believed was responsible for it, they had to read him this new thing called the Miranda rights. And it says, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be presented for you. Do you understand these rights as I've read them to you? If so, do you still want to continue to talk to me? And the guy said, no, I don't want to talk to you. I want a lawyer. I'm not going to answer your questions. And nobody was ever arrested or convicted for the murder of Ernesto Miranda, ironically. Right? Now, here's the thing I always like to talk to students about. Police officers are very good at getting you to talk to them because, once again, we feel obligation towards authority. We have to do what people in authority tell us to do. There's a great experiment called the Milgram experiment that you can look into for a psych aspect of this. We just obey authority. That's what we do. So when a police officer basically starts asking you questions, you feel very obligated to answer them. But you have no constitutional right to do that. And it does say that you have the right to remain silent. Anything you say can and will be used against you. None of this is going to be used in favor of you. I can tell you pretty much every single defense lawyer will tell you that your best bet is to keep your mouth closed, to not answer questions. In fact, in a lot of restaurants in the area, you'll see like these advertisements in bathrooms basically telling, it's a defense attorney basically saying, like, if you get arrested today, rule number 1, keep your mouth shut, right? Rule number 2, call me, kind of thing. No defense attorney basically wants to have to try to undo the damage that you did by answering questions to police officers. But once again, it's really hard not to answer their questions when they start asking you questions. So if the liaison officer calls you up to their office to ask you about a party that happened this weekend and that they heard you were there, you don't have to stay there and answer those questions. You could just get up and leave their office. You don't have to answer the questions. When a police officer pulls you over and asks, where are you coming from? Do you know why I pulled you over? You don't have to answer those questions because answering them might actually incriminate yourself. If he comes up to you and says, do you know why I pulled you over? And you say, well, yeah, I was speeding. You just confessed, right? So these are all things that are Miranda versus Arizona, the idea of the Miranda warning and stuff like that. So self-incrimination. All right. The Sixth Amendment, another defendant's rights, the right to an attorney. You have the right to an attorney. However, it's not quite like it is on television. For the longest time, it was believed that the Sixth Amendment, once again, only pertained to people who were charged with a crime, a federal crime, where you were looking at, or perhaps if it was a state crime, only if it was a capital offense where you might actually be executed for it. But the Sixth Amendment grants you the right to a counsel. It grants you the right to confront your witnesses in trial. It grants you the right to a speedy trial, that is a public trial, so that people basically can see everything above board. Along comes Gideon Wainwright, 1963. So Gideon is the defendant here. Gideon's a man in his 50s or so, and he's being accused of breaking into a pool hall and then stealing money from like the jukebox machine and the cigarette machine and from the cash register, and stealing some liquor from the place and stuff like that. Basically, they get an anonymous tip that said he was seen at that place, and so the police pick him up. They charge him with this theft, and when he's in court, he basically says to the judge, "I can't afford an attorney. You need to provide one for me." And the judge says, "I'm sorry, sir, we don't do that unless it's a capital case." So he has to be his own attorney. Horrible idea. There's a reason why law school is 3 years and costs hundreds of thousands of dollars. They are well trained. They know what they're doing. You don't. Don't ever be your own attorney. It's not going to work out well for you. So anyways, Gideon is basically convicted. He's sentenced to prison. I think he gets like 7 years in jail or something like that. While he's in jail, he writes his own appeal using the library from the prison and writing it on prison stationery. He actually writes an appeal, and he appeals to the appeals court. And eventually it gets all the way up to the Supreme Court. So it's Gideon versus Wainwright. Wainwright is I believe he was the Secretary of Corrections for the state that he was convicted in. And eventually the Supreme Court looks at his case, and they rule unanimously 9-0 in favor of Gideon. They say that you have the right to an attorney, even at the state level, even if it's not for a capital offense. You have the right to basically be provided an attorney. Now, unfortunately, most people think like, well, I'm 19 years old. I'm working a minimum wage job. I can't afford an attorney. I'm just going to have them provide one for me. That's not quite as simple as it works. In the state of Wisconsin, they have a formula as far as who basically is going to qualify for a defense attorney, for a public attorney, and oftentimes that formula hasn't been updated very recently, and it's very difficult to qualify for a public defender. You may think that you can't afford one, but that doesn't mean the state of Wisconsin is going to agree with you. And even though you get a public defender, it's not actually free. Public defenders still charge people. What they have though is kind of like a set rate. Like if you're getting pulled over, if we're going to defend you for a DUI, here's how much you get charged, kind of thing, regardless of how much time, effort they put into it, type of thing. So it's not exactly free. You can look at the Public Defender's Office website, and they kind of give you a list of frequently asked questions. It's pretty interesting to look at. All right. Now, going along with the defendant's rights, looking at trials, what most people don't understand is trials are actually pretty rare. They don't happen very often. A small percent, less than 10% of the cases that we basically hear actually go to trial. Most of them get plea bargained out. That's why when we try to go and visit a courtroom at the end of after our tests, we usually try to pick a date where we can actually expect a trial. And sometimes it can be really difficult. And sometimes we're lucky and sometimes we're not. Usually we've been pretty lucky. But what often happens is what's called a plea bargain. So a plea bargain is when the prosecuting attorney and your defense attorney basically will meet together and they will reach a compromise. Let's say you're being charged with, like 3 counts of felony assault. And what they might do is in the plea bargain is they basically say, okay, look, if you agree to plead guilty, we'll drop 2 out of the 3, and you'll basically plead guilty to 1 charge of felony assault. So they basically narrow down, they knock down some of your crimes or some of it, maybe lessen the charges you're going to be charged with if you agree to plead guilty, and then you avoid the whole, time-consuming and cost-consuming aspect of having a trial. And that's what happens to 90% of our cases. So there's some argument to be made that, our judicial system because it's overtaxed, it's overworked, it's overburdened, that oftentimes we're not seeing the justice that might be deserved because of, plea bargains are the norms nowadays. We've talked about the fact that most of you will probably end up in a courtroom at some place, at some point, sometime in your life. Maybe you'll be an attorney in a courtroom. Maybe you'll be a judge in a courtroom. Maybe you'll be a witness in a courtroom. You might be a defendant in the courtroom. Let's hope not. But you might also end up most likely being a jury member in a courtroom. So when we have a jury trial, they're open to the public. We were planning on going to see one. We'll see what happens this year. But what we can also expect is a jury that's going to consist usually of around 12 people that are going to be selected from the community at large. They're going to basically narrow that down. They'll actually start out with probably like 30, 40 people to start with. And then what will happen is the district attorney and the defense attorneys and the judge will ask them questions. Do you know the defendant? Do you know any of the officers involved? Do you know any of the prosecuting attorneys or the defense attorneys and stuff like that? Do you have anybody, if it's, in your family that's been involved in a case similar to this? Do you have any strong feelings about this particular type of case and stuff like that? And they'll eliminate people who they figure they might be biased. Then each team of lawyers gets so many X's, gets so many so many options to remove a jury member for one reason or another, to try to narrow it down to 12. And jury selection it's a scientific process. It's becoming very big business, especially in high-profile cases, to have somebody come in who can read jury members and basically try to figure out which jury members are more likely to, vote in favor of your defendant or against the person being accused, depending on which side you're on. And then these 12 individuals basically will be responsible for finding the individual guilty or not guilty. So they'll listen to all the evidence, they'll hear the opening statements, they'll hear the evidence, they'll hear the closing statements, and then they go back into a jury room and they'll deliberate. And then they have to come back with a decision that is unanimous, 12-0, in order to convict somebody. If you have one person who's holding out and saying not guilty, you get what's called a hung jury. And then the judge has a couple of options there. You can make the jury go back and deliberate longer, or if they just can't reach a consensus, you might get a hung jury, and then the person basically isn't going to be found innocent or guilty. And then the prosecuting attorney can decide if they want to try to retry the case again, this time with 12 different people to basically act as the jury. It's more complicated than that, but that's the simple version of it all. So, all right. Starting tomorrow, we'll take a look at cruel and unusual punishment, that Eighth Amendment protection. Once again, really vague terms, cruel and unusual, and we'll try to figure out what exactly those means. But until then, make sure you're safe and make sure you wash your hands. If you got any questions, let me know.